Greetings, colleagues and enthusiasts of corporate law turn-up. My name is Mathews Okoth, and I take this chance to welcome you to this program through which I serialize some of the lead corporate issues that arise in Kenya. Now, this is episode 9 of the program. In episode 8, I discussed the concept of overdraft facilities as part of a broader category of loan financing. In this episode 9, I discuss clawback rules and void dispositions under Insolvency Act in Kenya. Now, as many of you may be aware, the insolvency law aims to achieve some element of fairness to creditors in the distribution of assets. The whole essence of insolvency proceeding is to it takes away the individual right of claim by a creditor as against a debtor, and entitles that debtor to participate in these collective proceedings called the insolvency proceedings. Now, so that collective proceedings be of benefit to the creditor, there needs to be certain safeguards, particularly that preserve the assets of the debtor, so that if eventually these assets are distributed, at least they confer a benefit that those creditors are entitled to under the Act. So one of the aims of clawback rules is to prevent actions by company managers that may prejudice the statutory rights of creditors under the Act. At times, company managers can engage in actions. They can engage in actions that take away the assets from the general insolvency estate, or that have a way of circumventing the statutory scheme of procedure that is provided for under the Act. And so clawback rules are the rules that step in to preserve the sanctity, not only the asset, but also the sanctity of the scheme of distribution that is provided for under the Act. And even in instances where there is actually no distribution, the so-called non-terminal procedures of insolvency, such as administration, still, clawback rules are relevant in the sense that they prevent dismemberment of the assets of the debtor company. So that if eventually these assets are to be sold as a going concern, or if the debtor company is to be rescued, at least it's done in circumstances where the assets of the debtor company are intact. So clawback rules are not idle rules. They are serious policy objectives that legislators actually intend to achieve by including these provisions in the Insolvency Act. Now, the first of these transactions that actually can be invalidated is what is called transaction at an undervalue. And a transaction at undervalue occurs where the debtor company gifts or receives consideration from a creditor that is significantly less than the value that this debtor company is giving the creditor. Now, this transaction have to happen within a relevant time. And what constitutes a relevant time is described by the Act depending on whether or not this creditor and the debtor are connected or they are not connected. When we talk of connectedness, we are talking of relationship, either business relationship that these particular parties have, or family relationship. For instance, if the debtor and the creditor are part of a common group of a company, and they engage in some intercompany transactions that result in the debtor company actually gifting one of the subsidiaries in the group, or in a way just transferring the assets of the debtor to a subsidiary within the group, right? Those are connected parties. And if those transactions happen, if such transactions happen 2 years to the date when the winding up petition is actually lodged, then that is one of the thresholds that a person claiming that there's a transaction at undervalue will have met, right? So the point is, for connected, all transactions at undervalue that happen 2 years to the date of the lodging of a winding up petition, in the case of connected companies, can be deemed can be upset by the court if, of course, other considerations are met, which I will discuss shortly. Now, if the debtor and the creditor are not connected, then these transactions ought to have happened, 6 months, at least 6 months to the date when the winding up petition was actually presented, right? So relevant time is one of the considerations. Like we said, clawback rules don't just apply in the case of terminal insolvency procedures. Even in administration, the relevant time in the case of administration is that this transaction that is impugned ought to have happened between the date that an application to appoint the administrator was made and the actual date of the appointment of the administrator, right? Now, the second ingredient of a transaction at undervalue is that the debtor company must have gifted the creditor, meaning there was no consideration at all that the debtor company received, right? The third ingredient is that the debtor company must have received a consideration that is significantly less than the value that it gave this creditor, right? So, meaning the person that is moving the court has to quantify that consideration in monetary terms and persuade court that the value that this debtor company actually received is less than what an informed purchaser trading at an arm's length would have paid for this particular asset or consideration that the debtor company gave, right? So there needs to be some monetary quantification and a proof that whatever was paid by the creditor is less than the value that it got from the debtor company. Now, of course, that may appear basic, but there are very fundamental jurisprudential questions that have arisen around this area, particularly as to whether creation of security, right, in favor of a debtor company within a relevant time can also be challenged as a transaction at an undervalue, right? There is, in the ordinary course of trade of a company, they may be having, say, overdraft facilities that we discussed in our previous episode with a bank. And then maybe the bank, suspecting that this business is struggling, insist that so that it secures its interest, the debtor company creates a floating charge over its asset in respect of the overdraft facilities. Of course, if on account of that security, the debtor company receives further advances, then it will have received a consideration, so it will not be a gift. But the more fundamental question would arise if in two scenarios. First, if the actual advances that it receives are less than the value of the assets in respect of which security is created, can it be challenged as a transaction at an undervalue? Or if the security is created on account of a past debt, right? For instance, an overdraft facility that was given prior to the date of creation of this security, can it be challenged as a transaction at undervalue? And courts have held that whereas these transactions can be challenged under other headings that I will discuss shortly, it cannot be challenged as a transaction at undervalue for the following reasons. Firstly, creation of a security, what it actually does is it avails the asset as a security. It appropriates that asset for the payment of a loan, right? It's not of itself a disposition. Even where the nature of the security is a mortgage, where there's actual transfer of title to the favor of the creditor, there is still what is called the right of redemption, right? So it's not a disposition of the asset. Creation of a security does not dispose of the asset. So the question of whether or not the consideration is significantly less or does not even arise in the first place. So yes, creation of securities for may be challenged as void disposition under other heads, but not as under the heading of a transaction at undervalue. Now, the second transaction which can be upset by the court if it happens within a relevant time, what I call preferences. A preference arises where with a desire to prefer, a debtor company places one creditor in a pole position to the prejudice of other creditors. So with a desire to prefer this particular creditor, right? A debtor company, transacts in a way that actually improves the condition of a particular group or particular creditor in the event that this particular debtor company goes insolvent. And let's just unpackage that. Right. First, of course, we may observe that the parliamentary language there is not it's not very palatable. The use of the word desire to prefer. That's the language that Parliament chose. So, the desire to prefer, which Parliament refers to, is just the deliberate act by the debtor company to improve the condition of a particular creditor, so that in the event that the debtor company goes insolvent, the creditor will be at an advantage as compared to other creditors. And this arises particularly by creating securities in favor of a particular creditor. If the nature of the security which is created, say, is a fixed charge, what it does, a fixed security removes the particular asset from the general insolvency estate, meaning that the beneficiary of this security, the chargee, will have an exclusive right to enforce its debt as against that security, right, in the event that the debtor goes insolvent. So that actually is the whole idea about advantaging one creditor to the prejudice of others. You actually preferring one creditor to the other, so that this particular creditor will be at an advantage. It will have a right of claim over a particular identified asset. A fixed security means you have created security in respect of a specific asset, right? So that once a fixed security is created, it removes them from the insolvency estate. And if the assets of the debtor are to be distributed, that those assets in respect of which there exist fixed securities, they don't constitute part of the insolvency estate. All right. Now, the second right that the fixed security holder enjoy, fixed chargee, for instance, would enjoy, is the right to appoint a receiver, and the receiver will be obligated to exclusively consider the interest of the appointing creditor, right? So in that regard also, there is an advantage that the debtor company will then be conferring on this particular creditor. It will be preferring this creditor, right? So the relevant time remains the same with that of transaction at undervalue. For connected companies, it must have happened within within 2 years to the date of winding up petition. For unconnected companies, 6 months to the date of the winding up petition. If it is administration procedure, then from the date of lodging the application to appoint an administrator to the actual date of appointment. The second type of security that can be created to prefer, with an attempt to prefer a creditor, is what is called a floating charge. And a floating charge, I know some of you may have interacted with some literature that really have no legal sense. that a floating charge is a type of security that, hovers over general body of assets, and then it crystallizes, when a specific event happens, like if there is a default. That looks flowery, but it makes no sense. What a floating charge does is just to, give permission, consent, kind of, to, the debtor to deal with its asset in the ordinary course of business without seeking, the consent of the creditor every time it wants to deal. Is said to be a security over the shifting funds of assets of the debtor. For instance, over the stock of the debtor, so that a debtor can ordinarily even dispose of the stock. It can even replace, if it is a floating charge, most likely is all the in respect of all the assets of the debtor. So, including machineries, a debtor can actually replace its machinery in respect of which there is a floating charge, if it does so in the ordinary course of its business. So that leeway to deal is a security that gives leeway to the debtor to deal with the security in a way, in its ordinary course of business, in a way that does not require constant consent of the creditor. All right. So we said one of the alternative way through which the preference can arise is when floating charge is created in respect of the assets of the debtor company, of course within the relevant time. Now, as to whether more, like we said again when we were discussing transaction at undervalue, yes, there is the literal provisions of the act, but I think we need to go deeper and really try to understand whether this desire to prefer, whether it actually results in any preference, and particularly in the context of a floating charge. Right? Now, the aim of creation of a floating charge is always to put the particular claimed preferred creditor in a position where it benefits first in time. It benefits first in time as against other creditors from the insolvency estate. But as to whether a floating chargee actually would benefit from this security is doubtful. Why? Because if first there is a statutory scheme of distribution of assets under Schedule 2 of the Insolvency Act, and the priority of payment in when distributing the assets of the company actually puts a floating chargee way below other claimants from the same insolvency estate, right? The first in rank is always the payment for the winding up expenses, the costs and the legal fees that are incurred by the insolvency practitioner, right? Then there's the so-called preferential creditors, the employees, tax authorities, before you actually come to the floating chargee. And even if you reach the floating chargee, there is what is called a prescribed part under the Insolvency Act, such that, fine, on paper, there could be a floating charge created in favor of a creditor. But in practice, the effect of such a security creation may not necessarily be to benefit the floating chargee. Now, unlike a fixed security holder, we said the additional right that creation of a fixed charge, for instance, confers on the chargee is what is called the power to appoint a receiver. And before the enactment of the Insolvency Act, some of these procedures were lumped up under the Old Companies Act. And one of the powers that a floating chargee had under the Old Companies Act was to appoint what was called an administrative receiver. The administrative receiver had powers to also do what a receiver under the fixed chargee holds. We discussed some of these issues in episode 1 of this program. so that administrative receiver under the whole act would actually, enforce these floating charge security to the exclusive benefit of a floating chargee. That no longer happens under the Insolvency Act. The power, yes, there is a power conferred on a floating chargee to appoint administrator before the winding up proceedings actually commence. They can appoint what is called an administrator. But if you look at the powers of an administrator, they are to serve the interests of the general body of creditors. So there is no exclusive right to be serviced by an administrator under the Insolvency Act. So the bottom line, what we're trying to say is, yes, a court faced with a question of whether there is a preference needs to go beyond the literal provisions of the Act and ask whether in practice, in reality, there is actually preference. Because if it forms the view that there is no preference, then there is actually no violation of the Act. If the right that is ostensibly on paper, on the literal paper, conferred, is an attempt to confer on the particular creditor is not actually realized, then in my view, there will have been no violation of Section 683 of the Insolvency Act. Now, the third void transaction provided for under the Act is what is called a floating charge. Now, a floating charge as a void transaction, and is provided for under Section 687 of the Insolvency Act. What it states is that, in summary, if a debtor company creates a floating charge prior to, if a debtor company creates a floating charge, but consequent to creation of the floating charge does not receive any new consideration, either at the time of the creation of the floating charge or consequent to the creation of the floating charge, then such a transaction will be deemed to be a void transaction. Essentially, a floating charge created in respect of past debts is void under the Insolvency Act, particularly under Section 687. So, what essentially the Act is saying is that, fine, a debtor company can create a floating charge, right? But for that floating charge to be valid, it must be accompanied by what is called new money. Meaning, from either at the time when this debtor created the security, it must have received an advance from the creditor, or consequent to, right? So, if like in the scenario we gave when we were discussing transactions at undervalue, we said you can't challenge it. You can't challenge a security, a floating charge created under as a transaction at undervalue because there could be forbearance, but you can challenge it under Section 687, that this particular transaction secured past debts. So there is no new consideration that the debtor company actually obtained, right? There is no new consideration that the debtor company obtained consequent to the creation of this floating charge to warrant, creating this security in favor of the creditor. Ordinarily, in practice, in terms of enforcement, such kind of transaction are always enforced as a preference, right? If there is a tangible benefit that can be, shown to have been gained by the particular creditor on account of this floating charge. Now, when we say that, the new money, the new consideration ought to have been given at the time when you are creating the security or after the creation of the security. We are not saying that this transaction have to be contemporaneous. What the court actually will look at is if, for instance, consideration is paid before consideration is paid before the actual creation of the security, then that consideration must have been given while envisaging that there will be a floating charge created. For instance, if the bank makes some advances to a company in the morning at say 11 a.m. And the floating charge is executed at 5 p.m. in the evening, and it is shown to the court that when the bank was making the advance at 11 a.m., it was envisaging that there will be a floating charge signed by the parties to secure this particular consideration. Then it will still fit as a valid floating charge. Why? Because there is consideration, there is value that the debtor company will be deemed to have received on account of this floating charge, which consideration would then be for the benefit of the general body of creditors. The last void transaction is what is called extortionate credit transaction, which is provided for under section 686 of the Insolvency Act. And extortionate credit transactions are just sham transactions. They are transactions that are entered into in circumstances that are oppressive to the debtor company, or where the consideration is significantly less than the value that the debtor company is giving. And like you may imagine, extortionate credit transaction are always enforced just in the same way as transactions at undervalue. Why? Because the consideration that the debtor company is receiving from the creditor is materially or significantly less than the value that the debtor company is giving the creditor. So in summary, those are the void transactions that are envisaged under the Insolvency Act. And the clawback rules gives the court the powers to upset them in appropriate circumstances, so that whatever value that the debtor company lost on account of this transaction are then reversed and taken back to the general body, to the insolvency estate to satisfy the debts owing to the general body of creditors. Thank you very much for listening to me. Again, my name is Mathews Okoth, and I always appreciate your feedback. If you find this recording helpful, I urge you to continue subscribing to my channel. Thank you very much, and bye-bye for now.